Ladies and gentlemen, good evening. Welcome to the Europarechtliche Werkstattgespräche, our EU law workshop here at Vienna University. Most evenings we have a workshop in German language. Tonight it's in English language. That is not because our eminent speaker tonight would not speak German. He speaks perfect German. It's just that the terminology of the lecture that he's going to give, you said, would come to you more easily in English because since he wrote his opinion in English on the subject. Speaker tonight is Dr. Michal Bobek, the former Advocate General at the Court of Justice of the EU, but he is not just a former Advocate General, he's also an acting judge at the Supreme Administrative Court of the Czech Republic, and most importantly, he's also a visiting professor here at our university and faculty, for which I am very grateful and very proud to have you. And I think our students who followed your lecture this morning are even prouder and more satisfied that you're here than I am. Your lecture tonight will be on the ne bis in idem principle. The title is Ne bis in idem in the European legal space. Where does the law stand after the opinions in and the judgment? I focus more on the opinions. The judgments in bpost and Nordzucker. And I decided, you see that I have my sleeves rolled up, I have my collar open. It's a very hot day here, so I hope you don't mind. I hope you don't mind. We'll have an informal and open discussion. If you want to participate in the discussion offline, obviously, just stand up and raise your voice. Online, you can write notes in the chat, and someone from our team will read out those questions to Michal Bobek, and that's how you can participate in the discussion. What I was going to say earlier is that usually I thank everyone at the end, which has turned out to be very unfruitful because people scatter off at the end. So I would like to thank everyone in the beginning. I thank the speaker, but I'll thank you also at the end. But I also thank my team here. That is Johannes Lukan, Moritz Kopetzky, Julia Zöchling. Who else do I see? Okay, Daniela Schwind, who's outside, who take on all the organization and the administration for not just this European law workshop, but all of the Europarechtliche Werkstattgespräche, which we usually have 4 times a year. This time, or this year, we have it 5 times a year. So that's a lot of work, and it's very good work, and I'm very grateful that you all take on this task. Thank you very much. I also thank our sponsors, Ceha Hemper, who, and that is something that if you will just follow us online, will not benefit from, who support us for a luxurious buffet which has been prepared outside. Everyone in the room, please feel free to, before the lecture starts, already walk out, grab something to eat or drink. I don't think that's too impolite, as long as you don't make too much noise. So if you can't benefit from the buffet tonight, make sure to come at the next European Law Workshop, which will be in October, I believe, because Ceha Hempel continue to sponsor us. We're grateful for that, and I'm sure we will have another buffet in October. Come here and discuss with us and reflect with us on current issues of EU law. Enough talk. I see people are already trickling off on YouTube. No, they're not. But anyway, I'll make it short. Michal, if you're ready for your lecture, I very much look forward to your lecture, and we'll discuss afterwards. Thank you for being here.
Thank you. Hello, good afternoon. Hello, online world. Good afternoon. Thanks a lot to all of you for coming. I mean, by then you have proven your genuine interest in EU law, because indeed it's rather the weather for the beach, not really for talking about EU law, and especially just bizarre topics which I tabled. And from that, I take it you are really into EU law, because otherwise you wouldn't be there. And I shall try to make your time, your 40 minutes worthwhile, of explaining why, despite the rather boring topic, actually the content and the problem is a real one. And it's extremely interesting and relevant for the practice. Non bis in idem in the European legal space, why is there a problem? Well, or why should it be worth your interest being here now and not on the beach? Well, it's actually rather new and topical. The case law on non bis in idem and the protection has been evolving quite a lot, and the latest 2 installments are quoted in the name of the lecture, bpost and Nordzucker, with Nordzucker being actually a reference from the Austrian Supreme Court. So it is a very topical, important issue of quite some practical relevance. B, I will try to show to you it's also a practical example of the interaction, which is very often spoken of in theoretical terms, but very hardly quantified, and that's between the Strasbourg Court and the Luxembourg Court and the national courts, and the interaction and the talk on fundamental rights protection. How do the courts talk to each other in reality? Unfortunately, this particular area of case law is not perhaps the best example of a successful conversation which resulted into enhanced protection of fundamental rights, and I will also show you why. And above all, 3, the topic is in itself rather interesting, of trying also in a comparative theoretical way, of trying to project or expand the type of protection that has previously been possible at the national level into the European multi-layer complexity of many legal orders, and verticality, as well as horizontal complexity, okay? Multi-layered governance, and you shall not do the second time the same, it's problematic. So my 37 minutes will be pretty much in 3 parts. I will start with trying to explain the issues and the problems. Then I shall try to highlight how the problems evolved and why are we at the problem. And then introduce, the third part, introduce bpost and Nordzucker and try to interpret for you my understanding of where the law stands now in terms of the protection not being prosecuted twice for the same facts. So let us start with a notion. Non bis in idem. Actually, it's rather known, or in the popular parlance, perhaps better known, under the American expression of double jeopardy. And the logic is, as it says in the title, non bis in idem. Meaning, for those of you, and I'm in Austria, so I think the most of you have been tortured with some sort of Latin, which means not twice or second time about the same, okay? And quite frankly, from the phrase, which is nowadays enshrined in Article 50 of the Charter of Fundamental Rights, we are clear only about the non, which means you shall not, perhaps. It's up to discussion what it is, what it means to or second, and it's very contentious what's idem. What does it mean the same, okay? The same facts, the same acts, the same offense, but we will talk about it. And apart from the rule, which has been really elevated to the European level recently, we also do know the type of principle of not to prosecution or not to be followed twice, and we know them very often from national criminal law, where, of course, for quite some time, the same protection or the same rule has been present, or we kept defining it through national criminal law, okay? Concurrence of offenses, absorption, aggregation of fines. If I stab somebody, of course, I'm likely to be liable for murder if he or she eventually die. But at the same time, I actually damaged the thing by stabbing through the coat, and thereby I also committed something else, but that's likely to be absorbed into a much more serious offense, and so forth. So identity of offenses, we do know it's all around at the national level. The question is how to do it once we move it from the national level and from one legal order to the European, transnational, international, and when is that to be validly triggered? Let's perhaps start with 3 opening examples, okay? So that I do not talk so abstract. And since, by the number, you are pretty much the grand chamber of the Court of Justice, we can also start voting, really, if you like. What would be your take? Sorry, I always have problem with Belgian, Flemish names. Let's start with Van Esbrecht, okay? And let's think about the following scenario. Van Esbrecht was a Belgian national who took a load of drugs and took it from Belgium to Norway, okay? In Norway, upon entering Norway, he was intercepted by the Norwegian police and sentenced for drug smuggling. He spent some time in jail, then he was released. He returned back to Belgium, but once coming back into Belgium, he was intercepted by the Belgian police and charged with illegally exporting drugs from Belgium. So the Norwegians put him into prison for illegal importation of narcotics. The Belgians wanted to put him into prison for illegal exportation of the same drugs from Belgium into Norway. Back then, this was actually, it's already for me? No. Back then, this was actually still covered by Article 54 of CISA, which was one of the first non-bis in idem provisions even before the Charter, which is the Schengen Agreement, okay? But leaving that aside, would you say, can Belgians prosecute Van Esbrecht for illegal exportation of the drugs from Belgium? Or is the prosecution in Belgium barred by virtue of the principle non bis in idem? You shall not be prosecuted for the same. Let's leave in the space hanging what's the same here twice. So, who would say the protection of non bis in idem was validly triggered? Hands up, please, now. 1, 2, 3. Okay. Who says no? The Belgians can prosecute him? Ooh, the toughies. Okay, lovely. Yeah. Well, look, let's take a straw vote. Let's see how your opinion changes towards the end of the lecture, whether I have moved you a bit or not. But here we already start seeing the problems, because if I were now to unpack why you came to your vote, you might be laboring on the different visions of what is it identity of? And we start really going into the definition of the idem. Is it the identity of facts or material facts? Is it the act which shall be the same? Or are we talking about the offense or the identity of the offense, which shall be or shall not be the same? Based on that, we might already get to the different conclusion. Because if you say to me, for you, it would clearly be the offense, so the Belgians will say, we have it on our criminal code that it's an offense to illegally export. And the Norwegians will say, of course we have a criminal offense of illegal importation. So they are both covered, when you will, and for each of those, it will be a different offense. They might even say it's a different act. Of course, how much that makes sense within one and the same European legal space, where the idea is there are no internal borders. It's sort of, somebody has just imported drugs from Klagenfurt to Vienna, and we charge them with both? Unlikely, isn't it? I mean, what logic do you want to apply? But okay, that's Van Esbrecht. And the configuration here is, we have really something which is criminal and criminal. There is no doubt in both cases what we are looking at is Strafrecht, criminal law, pure and simple. Okay. Now, second, am I running too far? The second one and starts posing the same problem but from different angle is Menci. Menci was an Italian case whereby the persons there prosecuted would have committed VAT and direct tax fraud, and it would have been detected. So, as it normally happens, started being prosecuted by the public authorities here, fiscal authorities, and the fiscal authorities imposed fines, heavy fines, which actually in the book called Strasbourg, under the Engel criteria, are sanctions of criminal nature, okay? But that's administrative. On the top of it, when certain threshold was reached, the Italians also started criminal prosecution because the tax fraud was considered of certain gravity. There is no question asked that it was for the same tax fraud or let's say aggressive tax optimization. I mean, let's not be picklish, okay? Would you say, hands up please, who would say the non-bis in idem protection applies in this case and Menci cannot be criminally prosecuted for the same tax fraud if there was already administrative criminal sanction? So, who says non-bis in idem is applicable here? 1, 2, 3. Oh, it's interesting that you are on a different side now. That's a nice one. I mean, I hope it's not sort of advanced stages of split personality, but I would be actually afterwards interested why. But okay, who thinks non-bis in idem was not triggered here? And they can do that. Wow, completely different breakdown. Amazing, amazing. Okay, third example. Okay, sorry, why I mentioned Menci. Menci is actually criminal plus actually administrative, but because of Engel, that administrative is criminal by nature, hence the protection against non-bis in idem is applicable there as well, okay? We do have this little, I wouldn't say problem because it's being recorded, but there is the decision of the European Court of Human Rights going already back to 1970s, starting with Engel and then building up on that, which was originally issued in the context of Article 6.1 of the European Convention and the definition of what is criminal prong within the 6.1 European Convention. The European Court of Human Rights has always there embraced very expansive vision of what is criminal because, quite frankly, it needed to get back at administrative cases, which normally under 6.1 would not be possible to be reviewed under the Strasbourg Convention system. So you have rather expansionist vision, what is criminal, and that started with Engel, saying that certain types of proceedings, even if under national law labeled as administrative, typically administrative tax, environment, whatever other types of heavy penalties, including, of course, competition law, are now labeled as criminal in nature, which, of course, then enlarges the pool of the non-bis in idem cases, which must be reconciled within one and the same scenario. Okay, third and the last definitional example would be situations within which you are facing concurrence of administrative penalties, which are, however, evaluated as criminal. Typically, actually, the area of competition law, data protection, environment, and other network industries within Europe, where you have the concurring and sometimes even overlapping competence of national authorities, be it national NCAs, or be it the data protection authorities, or be it the national regulator for something, doesn't matter. And then the question normally is mutual or parallel prosecution of the same type of offense, which is either transborder or of European relevance. Actually, Nordzucker, in a way, is an example here, okay? Nordzucker, the case was really a cartel case, which included Austria and Germany. And the question which arose there was simply which of the national competition authorities is competent to prosecute and punish behavior which was very likely with some cross-border implications, but anyway, was condemned under 101, which implies trans-border activity or at least affectation of the trade within the Union. So, these are really the cases where we are having admin and admin. That one is transborder, but because of Anglo, they will be both seen as criminal because leading to criminal sanction. So whatever the protection against non-bis in idem should be also applicable there, or at least should be working there. And it can be within the same sector regulator, but it can also be a cross-sectoral regulator. Actually, bpost itself was within one member state, but across sectors, whereby the same type of behavior was sanctioned first by the sectoral postal regulator, but then by the National Competition Authority, okay? One is competent to sanction or supervise and sanction postal services and postal operators, whereas the other one is a transversal general national competition authority, which is competent for all areas of industry and business. So that would be like bpost, but you can also think, for instance, I actually don't know how far the case is, but for instance, there is another case pending along similar lines, whereby it's a cross-cut between GDPR and competition rules, where, for instance, the Irish National Data Protection Authority would be looking into some Facebook or Google, with all of them inevitably seated there. So it's the lead authority for all transborder processing under GDPR. But at the same time, the German National Competition Authority wanting to prosecute the same behavior as abuse of dominance under 102. Okay, is that possible? Anyway, it's the same type of behavior. Imagine, I don't want to name on record things like Google or Facebook, okay, whereby they would be prosecuted for certain violation of the GDPR in one member state, and the GDPR and the current system under the general regulation talks of exclusive competence for the lead authority for transborder processing. Does that preclude that the same type of behavior is then followed up and prosecuted by a national competition authority in another member state which seizes as abuse of dominance? So under a different regulatory regime, we are having the same like bpost just across in various member states. So these are pretty much the type of issues or problems. In which of these cases and how shall one define the protection against non-bis in idem so that it provides a fair balance in between, on the one hand side, the protection of individual rights. After all, by now it's in Article 50 of the Charter, and the European Constitution maker wanted the protection against second set of proceedings, prosecution, double jeopardy, okay? And at the same time, a reasonable way of running criminal and administrative procedures in the member states, because of course it's rather difficult to coordinate or bar everything which is going on in another member state or even in the same member state. So how do we distinguish that? And there I go really to the second set or the second part of my talk. It's the evolution of all that. And why do we have a problem? In a nutshell, the problem was, before Nordzucker and bpost, that over the years, the Luxembourg system of European law assembled 3 or 4 parallel regimes of various notions of non-bis in idem. And then came really the Strasbourg Court, the European Court of Human Rights, with very robust case law of the protection of non-bis in idem, which was very dialectic. Let me explain. Originally, where we had the first time protection against non-bis in idem in EU law was in competition law. Okay? Already in 1960s, when we go back to the cases like Walt Wilhelm, and I know, I'm sorry, I'm just writing on the second part of the board, which I'm not allowed to cross. But, oh yeah, that's still there. That's where it started in 1960s with Walt Wilhelm and this old case law, when actually even before we had anywhere in the Charter or the Schengen Agreement anything about non-bis in idem, we already had the thinking. And the older cases were really all about before there was an extensive harmonization of competition rules, or by now leading to unification in most areas under Regulation 1/2003, which essentially meant, or already before, that the national authorities or the national legal orders simply just recopied 101 and 102 into national law. So there is material identity of cartels and abuse of dominance, so we don't have this problem. Then, before all this happened, there was the problem of what to do in cases whereby the Commission in 60s or 70s would have started a set of proceedings against the same companies based on the same behavior, but this time for violation which were considered of European transborder relevance. And back in Walt Wilhelm, the answer of the court, which kept to be repeated ever since, most recently in cases in 2000s like Toshiba, was, look, there is identity of the offense if three criteria are met, okay? Or there is non-bis in idem is triggered, sorry, not an identity of the offender. Non-bis in idem is triggered if there is the identity of the offender, meaning the person, there is identity of the relevant, oh yeah, I know, sorry, but I'm out of words. There is the identity of the relevant facts, and the third criteria, there must be the identity of what was back then called the protected legal interest. And the logic was there that since the substance of competition was back then not yet fully harmonized, you could have had scenarios in which national systems could have protected competition either slightly differently or to a broader extent. By the way, that possibility still now exists under Regulation 1/2003, but is limited only to some areas. It's no longer possible under 101, it's possible under some sectors of 102, and it's possible outside of that if, for instance, the member state decides to go beyond. So that was really Walt Wilhelm. But ever since, in competition rules, we had these three criteria which have to be met in order to say non-bis in idem protection is triggered. Then came, however, Schengen. I mean, the Schengen Agreement, signed in 1986 in this small village in Luxembourg, which only the true connoisseur knew, okay? And within that, there is Article 54 of the TISA, of the Schengen Agreement, which was really, no one shall be prosecuted twice for the same act. So the word chosen there was act. And the logic was really one of one free space, whereby you can move freely. Unfortunately, you can commit crimes freely, but you will, I mean, of course, with consequences, but there is no bar against that, but for the law. But the logic was you shall be only prosecuted once and sentenced once within that free space without internal borders. So, however, from there was created the Van Esbro case law and the following case law, which was extremely narrow as to the identity, okay? Essentially, within the choice of, and going back in Latin, there is the possibility of really how do you define the idem, the identity, and the conventional distinction is you do either idem factum, which is only the facts, or idem crimen, which is the criminal qualification of the facts. There is your protected legal interest, which then allows you to distinguish in between various types of offenses. However, this case law was very narrow, leading to the Court of Justice in, for instance, Van Esbro deciding that Of course, somebody cannot be prosecuted for exporting the same drugs from the member state when importing them into a different state. It's all part of the same legal space. And there really the court embraced very strongly idem factum. It's only the material facts that matter. I don't care how the thing is classified under national law. So even if Norwegians had it on the books as illegal importations, and the Belgians had it on the books as illegal exportation, from the point of view of idem factum, it doesn't make a difference. We don't care. It's the same legal space. It's the same set of material circumstances which really make the crime. Okay? But that was, next to Wilhelm competition rules, that was another one which was really in criminal, which was really within the Schengen Agreement and criminal, but started evolving from there. Next to that, you would have really other parallel regimes which started evolving within EU law and which really came after 2000 or 2010 with the Charter and the Article 50 of the Charter, which talks about, surprise, surprise, offense. It doesn't talk about act. It doesn't talk about material facts. It talks about the identity of the offense. And now you start seeing the level of terminological and conceptual confusion. What really shall be encompassed as identity for triggering the protection against being prosecuted twice for the same? And under Article 50, and the earlier case law there, or later one, you would have mentioned, you would have Carson, Puma, another case law, which really concern primarily, or the first case of this sort would have really been Ackerberg-Franzen. Ackerberg-Franzen we used to quote in order to define when is a case within the scope of application of the Charter and fundamental rights, Article 51(1) of the Charter. But actually the material question in Ackerberg-Franzen was a Swedish surcharge on tax once you did tax evasion. And the system that the Swedes apparently do have is that if you did do a bit of a tax evasion, then firstly, you will be penalized, and secondly, you will get a tax hike for the next taxable periods, where as a type of the punishment, you will be put into the higher tax band. So even if you should have been paying, I don't know, 40% taxes, as a type of punishment for the next 3 consecutive taxable periods, you are paying 60%. Okay? And the question was, can they do it at the same time? Or is it non bis in idem? Is it the duplication of the sanctions, whereby they are being fined at the moment they committed the tax offense, and then giving the tax surcharge on the top of it? So those were the systems under European law, and on the top of it came Strasbourg. Because the Strasbourg case law before, and now really please bear with me for 5 more minutes. I promise I will get to a closure afterwards, but I promised you a study in European complexity, okay? And I shall live up to the promise. Because all this is just your EU law. And try to make sense of it within different regulatory regimes, okay? Which each of those have sort of protection, competition, criminal Schengen, general Article 50, and taxation, especially within VAT, which is a harmonized EU tax, hence you get a lot of cases on this. Strasbourg case law, I mean, there is an additional protocol under the convention, which prohibits non bis in idem. It's Article 4 of Protocol 7 of the Strasbourg Convention. And for a long time, the approach of the Strasbourg Court to this was rather, let's say, I shouldn't say lenient if somebody is watching this, let's say open. Because the previous cases before Zola Putin, I mean, now some of them would be coming actually also from Austria, like Franz Fischer and other cases, really concern parallel sanctioning in 2 public law administrative regimes, drunken driving. I sanction the person, and then on the top of that, I deprive him or her of the driving license. is it a second set of proceedings if two administrative authorities do that? Or is it not? I mean, normally it tends to be integrated, and very often is first instance criminal code, which will in two sort of type of operative parts say, this is the sanction, and you are forbidden from driving for the next 10 years. If you integrate it in this way, the problem doesn't arise. But there are some systems which have it separate. And then the question yet again is, non bis in idem? Yes? No? Maybe? However, all that really came in, was changed by Strasbourg in Zolokutin, which was a Russian case, okay? Zolokutin in Russia. And Zolokutin, on fact, was about, it was 2000 something, I don't know exactly, which was, on fact, was about a person who was verbally abusing towards police officers when he was being arrested and interrogated while drunk. And what they did on the basis of that, they started administrative proceedings against Mr. Zolokutin for minor disorderly acts, okay? But however, of course, on the angle, even that type of proceedings is criminal in nature because it leads to imposition of a sanction of a criminal nature. However, several days later, the authorities decided to reclassify that and reclassified the same set of facts to disorderly acts, which is a criminal offense. So, Mr. Zolokutin was firstly prosecuted and convicted, was certainly first followed administratively, and a fine was imposed, but then it was reclassified and prosecuted as criminal. Now, in that case, the Strasbourg court was very, far-reaching to the other direction, because what they said was simply that the protection, and I quote, under Article 4 of Protocol 7, which means the non bis in idem, must be understood as prohibiting the prosecution or trial of a second offense insofar as it arises from identical facts or facts which are substantially the same. So, from this choice, they boiled it down here to mere identity of facts. And then the hell broke loose, okay? Because, of course, when this was announced in the Grand Chamber of the Strasbourg Court, then a number of national courts were rather surprised by that, especially those which saw themselves barred, because, of course, from all these three opening examples, none of them would be possible, okay? They all arise from materially same facts. When we are at the level of facts, what have you done? When we bar away any expression or evaluation of the impact of what you did, or the threat to the protected social or societal interest, or even broader, the classification of the offense under national law. Because normally, when you talk about the definition of act or offense, in most of the systems I looked at, it tends to be facts plus either the impact, what did it cause, which is not supposed to cause, or impact and or protected legal interest. That's normally the distinguishing mark, where I am able to distinguish different type of crimes. Because, for instance, if I bodily harm somebody and causing death, it's an attack against the person. So the protected legal interest is bodily integrity of the other person. As opposed, by the same time of act, I also destroyed the person's property. That's an attack against another social good, which is property. Okay? And on that basis, we tend to be able to distinguish different type of offenses. And in a number of national systems, we are able to say you can do it as long as it's not the same, normally, the material facts plus some sort of evaluation. And that really, the Court of Human Rights said no, is really idem factum and put it very broad. Long story short, About 8 years later, it essentially was obliged to retract or reverse itself. In the next case, which was AB and Norway. AB and Norway was a case about tax surcharge in a member state, something not dissimilar to Ackerberg France we already spoke about. And there, the Court of Human Rights said, well, look, it's still the same identical facts which we are interested in and whether or not they are substantially the same. However, they added a different test or a new test. They simply said there must be within the two proceedings a sufficient proximity or close connection in substance and in time. Okay, and they developed it in twofold link. I won't be going there, but it's really a substantive link between the two proceedings and the temporal link. The problem there really is rather that there they were trying to reauthorize a number of possible parallel proceedings. However, of course, there they focused a lot at the outcome of the case and the sanctions which are imposed in the parallel regimes. Are they compatible? Is there substantive link, both in material or temporal? And of course, part of the issue was that you can only look into all of that once most of the proceedings are over, okay? Only then you see what sanctions was imposed. Is the combination appropriate, disappropriate? Is it commensurable to the seriousness of the offense? And so forth. And since I'm talking for too long, let's go to the third section, Nordzucker and bpost, and do it rather executively. Nordzucker and bpost were two parallel cases. One came from Belgium and the other one from the Oberste Gerichtshof. And they really provided the opportunity to try to put all this into some sort of coherent picture, okay? Because on the one hand side, you have the fragmented regimes under EU law. Then you have Strasbourg case law, which within 10 years overrules itself. So where are we now? bpost was the following. bpost was a Belgian case whereby what has happened there was that bpost, the national operator of postal services in Belgium, run some years back, I don't know, 2000 something, run a system of rebates for bulk sending and its customers who would be sending post in bulk. Essentially, they were saying if you post your bulk letters, advertising, whatsoever, leaflets with us, we will give you a special type of discounts on your postage, okay? What they were doing there essentially was to cut the middleman. And here I'm really quoting from the National Competition Authority, because in the point of view of the Belgian regulators, they were using their dominance upstream in postal services, downstream, in order to squeeze out postal aggregator services from the market. Essentially, the message was contract directly with us, we will give you special price, and we are able to provide the services of aggregation and postal packaging ourselves. And if you do it with us, we will give you a discount. That was found to be incompatible with the postal directive by the national postal regulator in Belgium. So the sector regulator for postal services, who said this behavior was discriminatory and incompatible with the directive and the principles of the treaty. The decision was first reversed, then annulled, but while this was still ongoing, came the National Competition Authority and sanctioned bpost for the abuse of dominance, which led into influence on the competition downstream and on the market or the adjacent market of aggregation of postal services. I mean, this middleman story. And the question was, can they do it? Or is non bis in idem validly triggered? And if yes, again, how do we define idem here? What's idem? Okay, the same set of facts, the behavior on the part of the undertaking. If yes, then the story is closed, really, because then it would be the second set of prosecution for the same set of material facts. Or, and here we connect back to Bald Wilhelm. If you remember, at the beginning I said in competition law matters, there was always three-pronged test of identity, including the same protected legal interest. Is the same also applicable when we are facing a case in there where it's competition and non-competition? Or is it just competition and competition? Or is it there still? Does it exist at all? And that was really bpost. Nordzucker was a parallel case which concerned same but different issue. And the issue in Nordzucker was simply market partitioning and the question of if a national competition authority finds an undertaking under 101, so implicitly for infringing the transborder nature or infringing competition at a transborder scale, whether or not a national competition authority in another member state can punish the same set of facts for the effects which took place on their territory. Nordzucker, Südzucker were two producers, two out of the three main producers of zucker in Germany. Because of the nature of the market is pretty much partitioned as it was. And the question, or the part of the Austrian part of the question, was simply branching out. Because what the German, the competition authority did, was they punished the cartel in Germany. But what they also did, mention in the facts of the case, and it was not entirely clear whether it also led into the effects at the national level, was a certain phone call that the directors of Nordzucker and Südzucker had on the phone around after 2004 about the Austrian market. Because there, essentially, the two directors were caught talking. And one of them was saying the Südzucker subsidiary is, I think, Agrana, somewhere on the public record, which is operating in Austria. And the parent company is Südzucker. And the Südzucker manager was talking to the Nordzucker director and saying, well, look, we see that you or your subsidiaries in Slovakia and Czech Republic now started supplying customers in Austria. And we would be very happy if you stop that. Okay? For that, we think that it's really our company that should be doing that. The director of the Nordzucker didn't apparently react to that, but a few weeks later, they really stopped the supplies from Slovakia to Austria. Okay, so there was some sort of consultation. We might discuss how far. The question now is, if the Germans and the German National Competition Authority has mentioned this in the narrative part of the decision, and they also say this was against competition, and they sanctioned all this under 101, meaning the treaty article, does it mean that they automatically also sanctioned that behavior on the Austrian territory? Or was it always only intended for the German territory? And there we get into the non bis in idem, but at the horizontal level across two member states. Long story short, the court decided, essentially, and the leading case here is bpost. So if you want to really have a look where now the test is and how should it be approached, you read bpost. Nordzucker is really a bit of an attachment to that. But on the crucial question of what's non bis in idem, the court did a bit of an evasion, okay? Which they already started off with mentioning, but now it was confirmed to everything. Why? Well, because all this discussion we are having so far is about the scope of the right. Non bis in idem, did we enter into the protection of non bis in idem, whereby we have two identical set of actions or two identical set of prosecution? What the court did in mentioning and now extended to all areas of law is it's actually no longer arguing about the scope of Article 50, which is what's non bis in idem and which of those are caught, and it does, but very rudimentary, and there is no need to go to detail. But it goes into 52.1, which is the limitation of rights clause, in order to discuss or to judge whether or not this is possible and whether there can be a second set of prosecution. How this would play out in practice, where you go into bpost, then the type of examination and how the national courts are now supposed to approach it, it's pretty much the issue of, look, are the two types of proceedings criminal in nature, which is really just the question of angle. And since the angle is so broad, of course, you will come to the conclusion that a criminal prosecution or an administrative one, which is leading to imposition of sanctions of criminal nature, is criminal in nature. So both of these criminal, yes. Is it the second set of proceedings? Is there a bis, which is normally, can it be an integrated whole? Yes, no. If no, then it's automatically bis. There is a second set of proceedings. And then one goes into the idem, which is they the same offender? Yes. And in order to comply with Zelot Putin and Russia and the narrow vision of idem factum, the last question at the level of the scope of right is it the same material facts? And then we are done under the scope of the right. But there comes something which actually isn't in the European Convention and which is in the Charter, which is a transversal clause on the possibility of limitation of rights, okay? Which then works in a case like this in the way of asking whether or not, of course, the second set of proceedings is, the second set of proceedings guarantees the essence of rights under Article 50, whether it meets an objective of general interest or pursues distinct legitimate objective, and whether it complies with the principle of proportionality. So, the classical transversal clause on limitation of rights. You can limit the scope if you are able to establish these. And what is quite interesting to see, where you get to the legitimate objective of the two types of the set of proceedings which they are pursuing, then you see that's actually the legitimate interest, or the definition of the offense is a bit reborn. Because how do you define different legitimate interests in pursuing this in parallel? Well, you go back into what is supposed to be prosecuted and what's the protected legal good, what you are pursuing. And in this way, it's a bit of a switch and bait trick, because the type of the discussion we have previously happened here at the level of the scope, in the sense of defining the difference in the protected legal interest or societal good, in order to ask, do we get in, will be under the influence of the Strasbourg case law, because it apparently cannot be any longer here, has been simply dislocated into the limitation clause, where when you read the type of discussion happening there, it's pretty much the same type of discussion, it's just moved to the level of limitation of rights. And that's really where the case law stands now, where the Court of Justice, the Grand Chamber, has tried to do its best of sort of complying with Strasbourg case law, which is very expensive, while, of course, at the same time seeing the necessity for allowing some sort of parallel regimes to go on, especially since what's inscribed into the Strasbourg case law of the proximity test, there should be sufficient link in material in time, it's very difficult to fulfill in practice, because they start recommending things like, you should be having integrated procedures at the national level in order to put it all together. Hunky-dory, that can work very well if you are looking at Article 4 of the 7th Protocol, which by definition in Strasbourg will always be only within one and the same member state. But when you move it onto the transnational area, it's very difficult. How shall the Belgians coordinate with the Finnish, not to speak of the bloody Czechs? And I can use that example, right? So from this point of view, the logic of integrate procedures, do it all holistically, it's great advice, but and that only, has difficulties running, as we see from Nordzucker, even within the integrated type of regime, as it competition rules, where we have extensive legislation. How on earth do you think it would work across regulatory regimes, across the member states? I mean, a Finnish environmental agency tipping off the Swedish competition authority. Oh yeah, perhaps they can't understand each other. Let's go to Estonia, okay? So from this point of view, of course, the multi-layered complexity there is mesmerizing. Let me conclude, since I'm already running over my time limit. The overall conclusion in all of that is, look, current state of case law in Luxembourg under the European Union, and one important clarification in bpost was also that Article 50 and this unified test shall in the future be applicable across the board to all the regimes. To all the regimes now, the fallback option or the general yardstick is Article 50, and this understanding of non bis in idem, which essentially overrule, implicitly at least, the old case law in competition. Essentially, what is being said, competition is not special, okay? Competition is one of the public regulatory regimes as all the others. I mean, competition law lawyers might be a bit unhappy about it, but that's where we are. However, one important element is the test is being unified. Second important conclusion is the current state of case law, essentially after Strasbourg, AB in Norway, and the Court of Justice in bpost, is, if I may be as bold, a good news for national competition authority, for national administrative authorities, but slightly less good news, at least in my opinion, for the individual protection. Because under that test, and especially under the limitation of rights clause, mention and the parallel regime in administrative and criminal for tax evasion can be very well justified, okay? Because there is different legal interest, and it's proportionate, and it's fine. So from this point of view, it is really, in order to try to accommodate the case law by now, and which is split across so many, I mean, stretch over so many regimes and so many situations, it really is rather open, which leaves open the question of whether the case law or the solution now stands correctly. And this is really my last point for this, which is on the dialogue in between the two courts. Because essentially, where you look at the landscape was Strasbourg went very far. Luxembourg felt, of course, obliged, also by virtue of Article 52.3, which is the homogeneity clause in between the Strasbourg and the Charter of Fundamental Rights, felt obliged to follow. However, seeing the real problem of if one goes along with Zolokutin, then one arrives at shutting down a number of parallel administrative regimes, which is hardly imaginable, then the evasion came to the limitation of rights, which, however, opened the box very far, which in practice means that most of these parallel prosecutions will be possible, will remain possible, which yet again is good news for the national enforcement, slightly less good news perhaps for the national, for the protection of fundamental rights. But of course, there is always Article 53 of the Charter and possibility of a member state within the scope of the member state to go above the minimum protection if some of them wish to do so. Sorry for taking more of your time. I run a bit over, but I'm very much happy if in this chaos you still see some interesting questions. I'm very happy to discuss them.
Thank you very much, Michal. I told you before that as long as you think you have something to say, you should continue to talk. And you did so. You had something important to say to the end. I thank you very much for your abundant insight into the problem.
I promised it was complicated.
Yeah, it's, I mean, at least from the notes, and your notes correspond to my notes, which are also chaos. But we can tell that this has been something that you've been working on for a long time, and it's also one could see the fire and the verve and the liveliness in your talk. So it's something that is very apparently very close and very dear to you, and it was very, it was a pleasure to follow your presentation. So you were not too long in any respect. However, I tend to be too long, which is already the wrap up of your talk, which is too long. So I look into the lecture hall, and also please online, should you have a question, type it now. We'll read it out to Michal Bobek. Bobek post it to you. Is there a question here? Johannes, please.
Yes, I have a question. My name is Johannes Lukan. I'm from the team European Law, University of Vienna. Do you think, Mr. Bobek, that it is in any way relevant for the homogeneity clause, Article 52.3, that medicine idem is not in the European Convention of Human Rights itself, but in an additional protocol? And as I understand, not all member states have ratified this, and there were some reservations by other member states. So, do you think that the homogeneity clause still applies?
Yes, I mean, there is no distinction between sort of substantive convention and the protocol. I mean, what you mentioned is absolutely correct, especially the abstentions or ratification with reservations, which regards Article 4.7 of the, Article 4 of the 7th additional protocol. But in a way, actually, on a personal level, I would say that should rather be message for the Strasbourg court, okay? If I have such type of provision, I don't think that would be the key of is it in the additional protocol as opposed to the main convention, because there it's evolutive, and I don't think they would be making such a huge difference. Where it, however, makes a difference for them is perhaps the level of abstentions, refusals, non-ratification, and the reservation expressed to what is going on. And I, at least for myself, always at the European level, was listening very carefully to the concerns of the member states, because very often they disclose something which is not trivial or perhaps might be overlooked. Whether or not, what the gist of your question, whether or not the Luxembourg court should be sort of interpreting the homogeneity clause a vitis variable dependent on that, I'm not entirely sure, okay? Because in a way, how would one do that? Saying that, for instance, and how would one make a distinction? When I'm thinking systemically, for instance, of Article 1 of the first additional protocol, right to property, is also an additional protocol, but everybody sort of sees it as really the core of the convention. Prohibition of the death penalty is also in one of the additional protocols. Would want to say, oh, because it's in the additional protocol, it's less serious, or no? So yeah, no. Look, I think this is really a case study of. If one is, because occasionally when I look at some of the papers, it's always very sexy to talk about how the two courts talk and how terrible it is and how the Luxembourg system has not subscribed to the European Convention and now they are running wild and doing whatever, right? Not really, no. I mean, one is really sticking very closely to what comes from Strasbourg. And sometimes even, in my humble opinion, certainly of an institutional one, going to very extremes in order to accommodate it verbatim, but then doing something rather interesting somewhere else in order to try to run a manageable system. Because I think one of the key differences, and that could be really a distinguishing point, perhaps, is simply that Article 4 of the protocol operates only exclusively within one signatory party. There is never a transnational element, okay? Could one be then running for a factual distinction in the scope and understanding of Article 50 of the Charter, which is in most situations, not exclusively, like sort of many type of situations, also within one member state. But the other ones, and most of them, are transborder. And transborder even either horizontally, more member states, or vertically or sort of diagonally, whatever you like, meaning national level and Europe. Should there be a difference? I don't know. Ideas welcome.
Yeah, thank you very much.
Thank you. I see another question, Professor Stöger.
Yeah, I just have to take this out of surprise on our answers. I mean, you're absolutely right, but you already gave the answer yourself. That's because from a domestic point of view, and Austria is one of the signatories of Article of the 7th Protocol. That's exactly the problem we have in the second case. Administrative law and criminal law on the one hand. On the other hand, how to adapt the case law by the European Court of Human Rights. So the cookie was a real problem for our constitutional courts. One of the cases where it simply refused to follow Strasbourg, as you are aware. So I think that's another challenge that CJ has to address. And I think it's well done if you combine a moderate Strasbourg approach with approaches which you also find from national constitutional courts, because that's probably the right way. The Sonderausgabe approach was simply too wide for cross-border and for domestic cases, in my opinion.
What I've been, however, mumbling about is, what does homogeneity clause mean exactly? Is it homogeneity in approach, or the homogeneity in the outcome, in the level of protection? I don't know. Your view is as good as mine, right? Because if one were to say homogeneity means, as it says in 53, wherever, it says the protection cannot go below, which would be then the outcome and the level of protection. So if I provide a level of protection, do I have to have, so to say, the same Lösungsschema as the other ones, or can I apply something slightly different, right? In a way, I mean, for Luxembourg, or where I look at this ping pong from the point of view of national courts, especially national administrative or constitutional courts, which are faced with sort of, and I hope it's not the Bermuda Triangle, then what are you supposed to do now? Because when you look at it, you are still bound, because all the member states of the Union are, of course, signatory to the European Convention. So you are, of course, still bound by this type of case law. And when you are within the scope of EU law, you appear to be bound by bpost and Nordzucker now, by that line of case law, which then would mean what exactly? What do you apply? Because here, you cannot do the escape to the limitation of rights, because there is none in the convention. So what are you supposed to apply exactly? Which of the approaches do you take? Perhaps nowadays, indeed, after AB and Norway, and these two together, they are actually, as to the outcome, quite lenient, quite open. And a number of things which previously, after Zola-Gutenberg shut down, are now again possible. But what do you write into your judgment now? Okay? 1, 2, both, neither, your own?
More questions? Maybe one follow-up question on that. Just as a food for thought, I mean, it's not my personal opinion, just as a food for thought. Do you think that exactly about this issue, that one could say on the transnational level, you could resolve to limitation of rights, but when you are in the same state, you will have the ECHR case law and you can have no limitation?
Yep, that's a possibility, of course, of course. The problem is, there's always a problem. The problem is, of course, I mean, when the two of them overlap. Because, of course, the transnational would be the scenarios under EU law, but under EU law, there are also a number of scenarios which are purely national, right? I was mentioning Menchi, and most of these cases really happen in VAT, because it's a harmonized EU tax, and a number of those are the question of sanctioning mechanisms for tax fraud and tax violation. Right, so there you face the same time, but yeah, the only problem is, of course, you have no textual support for that. Okay, so all of that you have to create ex nihilo, saying, well, it's of course possible that, or it's course necessary and foreseeable that Article 50 of the Charter was supposed to be applicable to transborder situations. That's quite a stretch, and you will still need it to purely national ones where it's applicable as well, if you are within the scope of EU law. But yeah.
All right, more questions. Do we have online questions? All right, then maybe I'll pose a question. I'll start with a simple question. Is my impression correct that you're slightly unhappy with bpost for everything that you said, evading the substance of the question, but also in general happy with it? So that's a very simple kickoff question. So bpost could be better, but is essentially fine.
No. I mean, bpost in terms of outcome was foreseeable, and it's certainly a way you can work with. What I was taking issue with was simply that applying the guidance, it's very difficult to say before the second procedure was launched and sanctions imposed. It's very difficult to run the test in bpost because you are not able to say whether the sanctions are proportionate and whether and so forth because they are not yet imposed. And the problem there conceptually is that non bis in idem is the bar to second set of proceedings and prosecution even from starting. It's not like, oh, let's run it to the end, let's see what happens. And based on the sanction, we say, oh, fine, I know, okay. So it's really not to be put in jeopardy. That's why double jeopardy, put in through the treadmill, so to say, twice. And okay, I see where you are going, perhaps full disclosure. Of course, I was arguing something slightly different in my opinions, where I was trying to re-establish the scope through protected legal interest and the differentiation there. I mean, I'm not that, I don't have such a problem because simply the same type of considerations simply move there, okay? The logic is the same. The distinctions are still possible, but are currently happening ex post facto, which then might be a problem from the point of view of fundamental rights. Because before all of this runs its course, I am not able to say whether it's proximity in time, it's proximity in substance, right? Because I don't know at that stage. And that's really the only issue. And that's why I was saying the dialectic of this going very far in one direction and that now going completely in the other direction. This type of jumping from one extreme to another, right? And that's why I was saying, very cynically, from the point of view of national administrative authorities, this is very good news. I'm not entirely sure about the scope of protection.
All right. Is it so? That's where my second. I look to the other, but maybe I'll just pose a follow-on question. That's where my second question kicks in by asking for more guidance or focusing on the identity of a protected interest. Are you advocating a one-size-fits-all approach? Is that what you're looking for? So the cross-cutting principles for ne bis in idem across all areas of law and all problems. So what I would provocatively call one-size-fits-all. Can that be the right solution for ne bis in idem, which is an effects-based, an outcome-based, and therefore a case-by-case approach necessarily? Question mark.
Not necessarily.
So is it not in residual? Can we not never solve this problem because we need a case-by-case approach?
No, of course you're absolutely right. At a certain level, it's individual. But however, by the way, you say it's effects or consequences, that's already a broader reading of identity. Okay? If you say identity only of material facts, it's what happened. I don't care about the impact. I don't care about the effect. Okay? So that's already something added, but fine. I don't think there is a choice really, because Article 50 of the Charter is transversally applicable. It applies everywhere where EU law is applicable. So to have a la carte regime, I mean, for what I was saying, I'm trying to reconcile that, at least in the opinion, it was simply the idea, look, Article 50 of the Charter, which is applicable everywhere where the Charter is applicable at 51.1, must be the floor for everywhere in EU law. However, individual regimes can go above. And one of those individual regimes, by the way, is what I mentioned already before, Article 54 of CISA, which explicitly differentiates between act and offense. Article 50 of the Charter is offense. CISA is just an act. One could be construing the logic, it's narrower, in the specific context of true criminal.
Yeah. Well, maybe I can also add on to this and clarify what I mean by effects-based approach. If I say you would have to take an effects-based approach, you need a benchmark. You need to know what effects are relevant on whom. And I think we do all agree that ne bis in idem protects the individual, then it should be the individual perspective on those factors, offenses, facts, protected interests, and it cannot be the public perspective. So what does that mean? It means that formalities cannot be applied or cannot factor into the disadvantage of the individual. For example, the Norway, what was it, Belgium or Holland? So the fact that formally those criminal codes are distinct, the definition of the offense is formally distinct, but from the individual perspective, it's one act. And there, in your examples, there were other cases that would support this. If you take an individual perspective, the outcome or the effects-based approach would mean the outcome cannot be that a mere formality is applied to my detriment, to my disadvantage.
No, definitely. The only problem with that is, of course, it would make sense, but then all the distinctions, or most of the distinctions we make in criminal law or administrative law are public interest based, right? For instance, I mean, when I think about the chapters or the heads in the criminal code, it's crimes against person, it's against public order, it's against property. And I agree with you, from the point of view of the individual perpetrator, it doesn't make any sense at all. He or she did only one thing. But we sanction it under the different heads for violating different notion of public good or different predictable interest. The same in administrative law. If I go take my car and dump toxic waste somewhere, I generally don't do these things, but hypothetically, if I dump toxic waste somewhere close to a river in Moravia, then by dumping the same amount of waste, I might have committed 3 or 4 administrative offenses at the same time, okay? Offense against the law on water, offense against Nature Protection Act, offense again. And these different regimes are yet again solely defined from the public good perspective. And one might even say, one might want to be explicitly nasty because by me doing that and by the same material facts, I might have transgressed against more interests of the society. And the question is, should they be protected? No. Yes, no. And then actually what was already discussed, then the logic of what Strasbourg kept recommending in Norway, AB in Norway, was integrated procedures, right? That's very thickly written in there, recommending the signatory parties, please would you make sure to, when you already want to penalize or follow this type of behavior, would you make sure that the Umwelt authority is talking to the other authority and they imposed one integrated sanction? But when you read it and know the reality at the national levels, it's sort of, okay, nice one, right? So, yeah, Dichtung und Wahrheit.
But that's exactly where fundamental rights kick in, because from the public perspective, the effectiveness perspective, you should apply criminal law and tax law and environmental law and administrative. The more you apply, the better from the public perspective. But the ne bis in idem principle precisely poses a limit to this over-application of public interests and the law, and that's why you can only take the individual perspective to interpret and inform the interpretation of that principle, I would think. And that's why the outcome must be to shield the individual from anything that from his or their perspective might be the same type of act and where mere formalities lead to the double jeopardy. Sorry, I talked too much. Do I see more? You're nodding. When I say this, you shouldn't be nodding. That's the point is taken. Any other questions from the floor here? I have more questions. Anything else? Anyone else? Online, offline? All right. Then I have a very theoretical question. Do you think ne bis in idem applies in the relationship between Articles 258, 260 TFEU, or given the conditionality and the values of the European Union, in the relationship between the application of that regulation and other sanctions that the treaties might foresee for violations of values or EU law or the rule of law? Is that also so? If I have obtained the judgment against the member state based on Article 258, is that already a sanction?
No, Because member state don't have fundamental rights.
The member state doesn't have fundamental rights. Okay, but theoretically, so would that be so no, yes,
No.
but would that be an idem?
So 258 meaning
So,
infringement procedure and the
I sanction the, I mean, I might come up with, but not now, with an example where individuals are concerned. And you have an infringement of EU law, and that is ascertained in due process in the court of law. And then later on, not damages, because I understand damages are not the problem of sanctions, but later on you impose a sanction for the same violation of EU law to the detriment of an individual. I just came up with the member states example, but if you think of, I don't know, damages that.
Oh, well, I'm not entirely sure I follow, but normally, I mean, I would normally assume that actually this is normally something which would already be happening at the level of member state, right? A parallel or concurrent liability on the various regimes. And by the way, another example of why we need the difference in protected legal interest or societal good. Because, for instance, imagine a judge infringing copyright. And a judge, for instance, copying without attribution of sources 200 pages from a monograph, which then, for instance, under Czech law, and I'm using that case because we actually did have some case years ago, whereby there would be a liability for that person, concurring one, either criminal law, okay, because infringement of copyright at a certain level is criminal offense property-wise. Then secondly, there would be a civil liability vis-a-vis the other publisher for damages. And then there would be an administrative disciplinary liability against the judge, which might even lead to him being stripped of the gown and removed from the office for the judge, since violating public trust in judiciary, blah, 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 blah. I mean, all these three are, in my book, absolutely possible because they pursue protection of different interests and follow from different types of legal relationships.
Thank you for answering my example, although it doesn't fly.
No, if I understood what you meant. And actually, the funny bit is, of course, we normally have sort of a type of ancillary order in the criminal proceedings, whereby the civil liability, if the claim is clear, can be sort of auxiliary part of the operative part of the judgment. Otherwise, you go into separate civil proceedings. The more tricky one is this one, because disciplinary proceedings against a judge, in terms of Engel case law, would be a proceeding of criminal nature. And there you go. Can you do that? In my understanding, yes, because the different types of proceedings pursue a completely different interest from different ranks and different ideas. But of course, on the extensive reading of the same facts and being prosecuted twice in criminal proceedings or proceedings of criminal nature for the same facts, meaning the person copied 200 pages without attribution verbatim.
Thanks. You make it sound like my question made sense, but I have another question, last question, yeah. Unless there's anyone else. And that question is actually less far-fetched. Did you come across the German bis in idem standard when dealing with Nordzucker? Why? What?
Which is? Sorry.
I don't know. My question is, did you deal with that? So how do the Germans approach that problem? Why? Because if there is a German approach to that and the EU law approach would be more lax, it could not be applied after the PSPP and
I think it could. Article 53, higher level protection.
From an EU perspective, yes, it could be. It could be applied.
I actually don't know. I mean, here, I in Nordzucker, I looked in quite detail into the national implementation laws, but that was a different question. Okay?
That's a misunderstanding. The national standard could be applied, but the EU standard, if it was lower, could not be applied, right? So the Nordzucker case might also want to discuss the German, or I don't know. My question is just, did you discuss the German standard? Did you come across it? Or would it not be that if the Germans had a stricter standard, that's what EU law would have by way of factual weight have to take over? Because anything that is less stringent.
But stringent for whom? I mean, more protective of the individual?
Less protection for the individual who infringed.
Well, that's hardly possible now. In factual terms, okay?
Yeah.
If you are saying, oh, it can all of the be if I am accommodated under the limitation clause, and that one is actually interpreted rather broadly, so the standard is already rather low. And it would actually mean, and it led in cases like Michal, that you can even have a parallel proceedings for the same tax offense under administrative and criminal within the same member state. For me, for instance, that would be actually the minimum bar where you can coordinate. Come on, you must decide yourself whether you will prosecute this guy criminal or administratively, or if you do it already administratively, you just suspend it or absorb it, do whatever you like. But please don't pretend these two don't exist, right? That should be integrated. But even that is possible now under the test. So from this point of view, from the level of protection, it's difficult to imagine or figure how it should be more lenient, or in this sense less protective of the individual as it is, right? So the floor is rather low.
I see, right. Thanks. Johannes.
I have a very last question, because you mentioned this copyright case from Czech Republic before. Just very short question. Do you think that because in intellectual property law you often have punitive damages, something like for a copyright violation you can claim like double the license fee or something like that? Would you say that these punitive damages would qualify as a criminal nature under the Engel criteria?
Yeah, but why it was here, actually I never really understood, but it's still in the Strafgesetzbuch book in the Czech Republic, we do have a criminal offense of violation of copyright, okay? It's there. I personally, conceptually, don't understand why. To me, it's a private offense. And if you have a problem with it, go after him in civil proceedings if he or she violated your copyright. I mean, why should the state be running your claim for you? But you can have different conceptions of what's criminal. And here, under national law at least, it's simply a matter of classification. It's on the code book, okay? It's a violation of copyright and it's on the code book. And from this point of view, if it's on the code book, then normally one is not obliged to run the test of the Engel criteria, but it's criminal in nature because it's subject to criminal proceedings, criminal prosecution, and all the palette of the criminal sanctions. Where one normally would be running, if I understood what you are meaning, that would be to the administrative side of it, and whether or not what you are imposing there is a sanction of criminal nature. The three Engel criteria under which one says it's a proceedings of criminal nature. And the severity of sanction is one of those, okay? So what are you imposing in that type of proceedings?
Okay, let me maybe briefly reformulate the question. So it was maybe it was about, for example, in a copyright violation case, if you have the statute that the copyright owner can claim double the license fee which you would usually get from the infringer. And is it possible to say that if the sanction is awarded, like, because it doesn't get just the license fee, the fictitious license fee, but double.
Yeah, so okay.
It's probably a sanction. So would you
So
say
if essentially punitive damages in a private law claim, would it make a criminal nature? No, it can't.
It is awarded to a private party?
Yeah. Normally it shouldn't, because not all this is always applicable to the state coming and sanctioning. So it's a gray zone of administration. I would have to double check, I'm not myself sure, whether anybody ever tried to apply Engel to purely civil law cases in view of the damages awarded. I hope not, but I would have to double check, right? I mean, interesting question. I hope nobody went that crazy, but quite frankly, it wouldn't be necessary from the point of view of the base structure of Article 6.1 of the European Convention, because there always you had the civil prong and the criminal prong. And what always why these two tended to be interpreted rather extensively was to get to the middle, to the administrative claims. And that was always the story of then Engel criteria of expanding criminal to the administrative sanctioning regime. But there the common denominator always being is the state, which it provides for the sanction. And from the other side, there was always this logic of which then a number of state signatory parties had a problem with, of sort of Viljo Eskeninen against Finland and others, where they were trying through the broad, extensive interpretation of what's a civil claim to get into Dienstrecht, okay? So typically saying that, oh, well, it's essentially a civil claim if you have been dismissed from a public function and then you are trying to claim your outstanding pay and so forth. Oh, that's essentially civil in nature. So it has been always the game in order to narrow the middle. But I wouldn't say it would have been crossed in this way, at least I hope not.
All right, thank you. With that, I think we should leave it with, I have exhausted your patience here online. Michal, thank you very much for your insights, your presentation. I certainly have learned to tell a lot tonight. And I hope you will come back for, I mean, you will stay here as a visiting professor, you'll stay here for the students. I hope you'll come back maybe for another presentation.
And I promise to select something more digestible if you want to.
That's fine. It's just, we have to find our way around the notes, but otherwise, perfect. Thank you so much. Thank you for coming here. Thank you again, everyone who participated and helped in the organization. Thank you to the sponsors. And we'll see you again next time after the summer. Have a good summer and goodbye. Good evening. Bye-bye.